send it over correctly. Good morning. As you're aware, each party will have 15 minutes in which to present the case of your account, and you wish to retain up to 5 minutes for rebuttal. Let me know when you come up to the podium. I'm keeping track of the clock, and keep the trial as fast as you can. We are being visually and audibly recorded and posted online. Please try to remain by the podium as much as possible. If you intend to refer to a child during your argument, just use the child's initials if you intend to. And we have your briefs and we're ready to proceed with more.
Thank you. Good afternoon. I'm Barbara Rogoshevsky. I represent Paul Behning in this case, the appellant, and I would ask to reserve 5 minutes for rebuttal.
Thank you.
Since 2014, Appellee has been attempting to convince the Ohio courts to nullify the effect of a Texas child support order, something that Ohio courts do not have the authority to do. Only the Texas courts can affect a Texas court order. But instead of addressing her dissatisfaction with the Texas child support order in the Texas courts, she has elected to keep coming to Ohio and asking Ohio courts to essentially cancel a proper child support order for this child so as to affect her total net payment. Following issuance of the February 2014 agreed judgment entry, first she requested a mistake of fact hearing at the Child Support Enforcement Agency. They declined to change the order as they did not have the authority to do so. When that didn't give her the result she wanted, she came back to the Domestic Relations Court. There she convinced the magistrate to modify child support using the exact same financial information, but to make a sole custody support order adopted by agreement a split custody calculation. That resulted in nullifying mother's agreed support order and ordering father to pay child support for a child not subject to the jurisdiction of this court. We objected. The judge ruling on those objections properly found that a split custody calculation, which includes a child subject to a foreign jurisdiction, violates the UCCJEA. However, then the trial court then attempted to again nullify the Texas order. First, the court properly prepared a child support guideline worksheet, again using all the same financial information as was in the order of February 28, 2014, but also including father's new child support order out of Texas, which was proper. However, the court then deviated from the guideline amount and ordered mother to pay zero child support. Interestingly enough, the magistrate, when she held her hearing, specifically stated that she was not making any ruling on the issue of deviation, which mother had brought before the court by motion. Yet the trial court went ahead and issued its own order deviating when the magistrate had declined to do so. In Fields and Farmer, this court found that the trial court must first establish that there has been a change in financial circumstances such that the guideline support would change by at least 10%, then warranting a modification of child support. Once the court determines that the child support would modify by at least 10%, then the court can consider a deviation. Thus, a modification is a condition precedent to ordering a deviation. In this case, the court ordered a deviation to zero, even though its own calculation does not establish a change in the guideline support of at least 10%. And it is not possible that it could have. You may recall that the February 2014 agreed judgment entry had a step-up support order, as both parents' financial circumstances had changed while the case was pending originally. The first motions filed in this case were in 2012. We went to trial. We were scheduled for trial in 2013. We made an agreement off the record that didn't make it into the record, and then the parties could not agree on what all of the off-the-record agreements consisted of. So then we had to schedule a whole new trial. That took another year. So when the parties came back for their second trial date in 2014. There had been some changes in financial circumstances, so those changes are reflected in the two support orders that are attached to the agreed judgment entry of February 28, 2014. The Exhibit B to that judgment entry shows that mother's guideline obligation is $448.57. When we look at the judge's calculation in June 2017, which is the ruling on objections, the judge in her calculation used all of the same numbers as were in the 2014 calculation, except that the judge's new calculation also included father's child support obligation to mother, which had been ordered by the Texas court, and that was about $350 a month. That had not been in the 2014 calculation because there had been some overlap in the proceedings. The judge's calculation, which does include that support obligation, actually increases mother's support based on the guidelines from $448.57 to $455.67. So not only does mother's child support not decrease, it actually increases according to the judge's own calculation. And that increase is only about 2%, not the 10% as required by the statute. According to Farmer, because the new calculation does not meet the 10% threshold pursuant to Revised Code Section 31-1979A, the court was not permitted to even consider a deviation. Thus, the trial court's judgment of June 21st, 2017, deviating mother's child support to zero must be vacated because the court did not have the authority to do so. I start with assignment 3 because I believe that really is the heart and the crux of this issue. We did have other objections and thus other assignments of error, but I do believe this is really the major issue in this case. However, I do want to briefly touch upon our other assignments of error. First of all, when we filed our objections, we filed 4 objections. And as this court is well aware by its own case law, when the court is addressing the issues presented in objections, the court must address all of the objections and rule on them independently. In this case, the court failed to do so. They issued a new child support order, but what they didn't do is actually address 2 of the objections that we brought to the court's attention. And this court has, on many occasions, and we've cited those in our brief, sent these cases back down to the court, told them you have to rule on all of the objections. The last issue that we brought up to the court's attention was the fact that both the magistrate and the judge issued new child support calculations without the supporting documentation required in Revised Code Section 31-1905A. It's very well settled law that the court cannot issue a support calculation and order without taking evidence. And we objected to that repeatedly throughout the course of the hearing before the magistrate. Without evidence, the court can't make a finding as to what the party's incomes consist of, the cost of health insurance, how much has been paid on the support that was previously ordered, or any other necessary issue for a proper support calculation. In this case, what the court did was take all of the information that was contained in the previous support calculation adopted by the agreed judgment entry February 28, 2014, and simply plopped it into a calculation issued in 2015 and then again another one in 2017. And that's not permitted. We repeatedly objected to the fact that we didn't have any new information. And because of that, the court could not consider a modification without updated information. We submit that that's still the case, that the court was without the authority to issue a new order based upon old information. However, the fact that the court did issue a new calculation, coming back to our third assignment, the information that the court did have at that time, it isn't possible that there could have been enough of a modification to even substantiate a deviation, because the court was using all of the same exact number. You can't get a different result by doing the exact same thing again and again. I think there's some cliche about doing the same thing again and again is the height of madness, because you can't expect a new result. Well, that would be this case. Using the same calculation again and again does not create a new result. It doesn't result in a 10% change in the overall guideline amount. And therefore, it doesn't give rise to a legal ability to consider a deviation from guideline support. I don't know if I've used up the 10 minutes that I asked for.
5 minutes and 10 seconds left, so you're right on time.
Okay, well then I will concede the podium.
Yes, Your Honors, may it please the court, I represent the appellee in this matter, Ms. Janet Behning. And before starting, I would like to point out to the court that her prior attorney for the purposes of the litigation of this matter was Scott Stevenson. And of course, Scott Stevenson became magistrate in the domestic relations court. After Scott was placed in that position, Ms. Behning was referred to me to do the appeal. I just want to talk about just a few matters here which have been touched upon by the appellant. She talks about the fact that the court did not have the jurisdiction to modify the child support, and she talks about the fact that also that the court did not really have a change in circumstances in which to work with. Well, first of all, the court does have the jurisdiction to review the child support. And what took place here was, initially there was a split custody child support worksheet that was put together. And since it was recognized by the court that they could not do that, that they went ahead and discarded that, and they used a child support worksheet showing the plaintiff in this matter having sole residential custody of the child, JB. And that's the male child of the parties that the appellant has custody of. So the court had jurisdiction under 3127.01, and they certainly had jurisdiction to modify this amount. And there's a difference of income here between these two parties, and the difference of income is significant.
Counsel,
Yes.
I'm sorry, I'm missing maybe part of your argument. So I know you said this in the brief as well, but you're saying that the court has jurisdiction to entertain a motion to modify child support, but you still have to determine, the court still has to find that there is a 10% deviation.
That's correct.
And where is that, I guess is what I'm
The
trying to say.
deviation is the fact that they took the child support orders, which were in the neighborhood, I believe, there was a determination made that on September 24th, 2012, the parties were ordered, they came up with an amount of $448.57 per month, and the agreement was that the plaintiff would pay support for Jared in the amount of $389 per month, and that was in January 2012. Now, subsequently, what happened, even though that agreement was read into the record, as a result of the hearing and so forth, the Texas court issued an order on January 13, 2014, reducing the plaintiff's monthly support obligation to JB, that is the female child, to $350.
So
And the amount
father's
of,
child support.
pardon?
So father's child support obligation was reduced.
Yes. So from the point of view of what the parties were paying pursuant to the Texas support order, when the parties were deviated down to zero by the court, which again was a very wise decision because you have a situation where one of the parties had a minor child living in Texas, the other party had a minor child living in the Akron, Ohio area. And if you're going to assess the parties for child support, there certainly isn't much left for expenses, considering the fact that the parties would have to travel back and forth to enjoy companionship. And that's a regular practice of the courts in Summit County. And that's why I want to point out when the appellant points out that there's been an abuse of discretion, there's no arbitrary, unconscionable, or unreasonable decision made here. Far from it. What the court did, acting as it did, they went ahead and they used the information from the child support worksheet that they had. That's taking the husband's, or I should say the appellant's income at approximately $81,000, and the mother was only earning $45,000. Now the husband was paying $1,600 a year for health care. But what the court did was it fashioned an order that was a deviation that represented both parties to have additional funds in which to visit and have companionship with the children. And that is done quite frequently. And it was very reasonable, it was not arbitrary, the court was acting in the best interest of the children. I also want to address too that the point that counsel has made that somehow the court is or has to rule on all of the objections. And in support of that, she points out a particular case in her brief involving PNC. But upon reading that case, what you learn is that as far as objections are concerned, that is objections that are made to the court, the PNC case stated that even though you have to rule on the objections, there are times when you don't have to rule on all of them simply because they basically contain the same issues as the other objections. In the PNC case, what happened was the court didn't rule on all of the objections, and there were 3 objections there that weren't ruled on. But those involved separate issues that needed to be ruled upon and were not nullified or rendered useless by the other 2 objections. And in reviewing the objections that were made by the appellant, the court in this decision essentially just nullified the other objections. I mean, you could have a situation where somebody could present a laundry list of 12, 13, 14 different objections and then force the court to rule on all of them. And if all of them were of a similar nature or dealt with a similar issue, that necessarily wouldn't be good judicial economy, nor would it really make sense because the matter has been already addressed.
Counsel, when we do our opinions, and we have assignments of error, we deal with every single assignment of error, even though it may overlap.
I agree with that.
And we just say, you know, this takes care of this assignment.
Exactly.
You know, so
Yeah.
why was that not appropriate here?
I can't explain why the court didn't do that. I'm just going to point out that quite frankly, I can't speak for the court on that issue. But when taking a look at what took place in the entire decision itself, I don't think that because of that, the appellant was prejudiced in any way. Certainly not. So that would be my response to that. But I can't explain to you why the court did not indicate in its decision as to why it didn't dispose of all of the objections. And I would like to point out one last item here, and that is simply this, that in the appellant's answer brief, or response brief to me, she stated that, I had stated in there that that I had claimed that the appellee had stated that the Texas court, or the court had adopted the Texas court support order and, or ruling, and quite frankly, all we did was, we just pointed out that the Texas court just went ahead and just used the, or that the Summit County Court, the Summit County Domestic Relations Court just went ahead and used the figures from the Texas court child support order, not that it had entirely adopted it.
And that order is in the record.
Yes.
But I have a question. The Texas order of support for the child and Ohio order of support for the child, is the parent paying two separate child support orders for the same child?
Could you repeat your question again? I'm
There's an
sorry.
order for a father to pay support for the daughter
Correct,
in Texas.
correct.
But it appears that there's an order from to pay in Ohio as well. Is that true?
No,
Is the amount he's paying in Texas accounted for on the child support worksheet somewhere?
yes. Yes. And also, the other point I want to make too, and this came to me just before, about a day or two before I filed the brief, but there was an administrative hearing that was conducted by the CSEA indicating an overpayment of approximately $10,204.90. And
Is that part of the record, counsel?
yes, and the appellant never really pursued that in terms of filing an administrative objection to that or mistake of fact. But this case is certainly a very, very, very convoluted case because there's certainly been a lot of time, a lot of money spent, at least from my point of view, and when I initially took a look at this case, I really felt that there was way too much litigation here for a matter involving not an insignificant amount of money, but when you take a look at the legal fees, vis-a-vis the case itself, it really doesn't add up to much.
Well, the children are both over age 18 at this point, aren't they?
Correct, Your Honor.
It must be coming to an end. Thank you. Thank you. Just over 5 minutes.
Thank you very much. Again, I want to address a few of the points that counsel made in his argument. First of all, there was some discussion about whether the Domestic Relations Court has the jurisdiction to review and or modify a child support order. Certainly, the Domestic Relations Court that issued the child support order for the child that is subject to the jurisdiction of this court has the legal authority to review its own orders and modify them should they meet the legal standard. So we certainly agree with that. However, at no time does the court have the authority to issue any order with regard to the child who is subject to the Texas court's orders, who lives in Texas, even insofar as trying to nullify or temper the effect of a Texas court order on one of the parents by altering an Ohio order. And that's essentially what Mother has attempted to do throughout the course of these proceedings since February 2014. Counsel also referenced the fact that Texas had reduced father's child support. If you look at the child support order and calculation from February 2014, there is not a support amount for father included in that calculation. When The court did its new calculation in 2017 because Texas had issued that order. They included that in there. So that represents a distinct difference in the two calculations and the only distinct difference. And as I said earlier, that causes an increase in mother's support in our calculation, not a decrease. But yes, that is in there. Counsel also mentioned that it's not an abuse, the court's order in and of itself from June 2017 was not an abuse of discretion because it was not arbitrary, it wasn't unconscionable, it was well thought out and well reasoned. The abuse of discretion is in the fact that the court did not apply the proper law to the facts of this case. Regardless of whether the court's heart was in the right place in trying to fashion an order that they felt was fair and appropriate, they still have to follow the law. And failing to follow black letter law, the law of this district, and the statutes that apply to all Ohio courts, that's the abuse of discretion. Counsel also mentioned that the trial court does not have to rule on all objections if they contain the same issues. And the PNC case does say that. However, if we look at these objections, they don't all contain the same issues. All of these objections are very distinct. One of the objections pertains specifically to the court's authority to issue a support order for a child that is not the subject of this court's jurisdiction. And the reason we objected is because the magistrate's decision issued a support order for father to pay child support for the child in mother's custody in Texas. And I think that's maybe, Judge Schaefer, where your confusion might have come in, that at a point in time, father was in fact ordered to pay child support for both children, even though one of them was in his custody. He was ordered by the Texas court to pay child support for the child in Texas, and he was also ordered by the Ohio court to pay child support for the child that was in Texas. And that's why we objected based upon the UCCJEA, because the court didn't have the authority to issue that order. But the other objections consisted of the fact that the court failed to hold an evidentiary hearing. That's a very separate and distinct issue from the jurisdictional issue. And the court never addressed that. So that's not the same issue. It's a very different issue. And it's an abuse of the court's discretion not to address it. I can go through the rest of them, but I think you get the point. In addition, counsel also mentioned that the CSEA found an overpayment and they had a mistake of fact hearing. I would like to add, those are not in the record. Those things all happened after this appeal was filed. And I have no doubt that the CSEA made a finding of an overpayment because the trial court zeroed out mother's child support retroactive to 2014. So of course we found an overpayment. They were basing that on, I assume, the trial court's order. But regardless, that's not a part of this record. It's not a subject for this appeal. And no doubt, depending on what happens to this case, if it's remanded, they may be readdressing that issue. But it's not the subject of this case.
With that, you're out of time, so thank you both for your
Thank you.
presentations today. The court will take the matter under advisement and issue a decision which will be mailed to both parties as well as posted to our website events.